It's a pleasure to be here. I think I was a bit lazy and I did not update my bio properly. So because of like the last time I presented here, I presented about cross-border solvents, but I'm a member of number of maritime groups as well. Uh, but today I'm going to talk about something that I have spoke like a lot about, like jurisdiction, in particular flag state jurisdiction. But before I start, I want to give the background of this research because there are two persons here. One that was the kick, like that gave me the kickstart for this research, and the other one who was also present when I decided to keep this research going. So the person who gave me the kick in the butt to start this research was Professor Thomas. And why?
Guilty as usual.
Guilty as well. Because I submitted to him around 2020 an article that was more about commenting about flag state jurisdictions in seafarers' contracts of employment under English law, in terms of English law. And he said to me, Julia, this is not an article. It's more of a case comment. So you have to reduce it. Let's make it, so reduce the number of words, make 2 case comments, because it's not like an article in itself. And this was during COVID, 2020, many things happened. I decided to go back home and I started to work in a mining project, nothing related to maritime law whatsoever. And then I thought to myself, should I do this case comments? And in the UK, you have something called the REF, which is Research Excellence Framework. And therefore, whenever we publish something, we have to prove the contribution to the body of knowledge, its contribution to the body of knowledge, its impact, and its originality. Case comments do not have any of that. So they are worthless according to British universities. So I decided I'm not going to do a case comment. I'm going to go ahead and do the research. And then Raphael is here. And then last year, when I was in the London University Maritime Law and Policy Group conference, someone raised like the whole issue about like cargo in terms of like contracts of carriage, if the damage occurred like of the cargo, like occurred in the high seas, the flag state would have jurisdiction over it, over the conflict. And I was like, no, not really. My business law, my commercial law brain was like, we have like contractual clauses. We have like, why would that be so like? We're giving too much like it's strong, too much power to flag states. So this would not be the case. And then it's like, okay, so I have to prove my point. So I'll do research to prove my point because I'm a woman. I have to prove that I'm correct, that I stand correct in my arguments. So this is how I started. And just because like, and also it's because in the international context, we give like, we always have this tendency of claiming the flag, of saying, oh, it's flag state jurisdiction, let's impose so much responsibilities in the flag and et cetera, and we always talk about flag states and so on and so forth. But why I have this picture of the ocean? Because the whole reason like we created like the registrations and flags was because otherwise like vessels were only lawless shuttles at like one point in time. So they were not regulated. So anything that would happen in the high seas would just happen. So if somebody was to die in the high seas, they just died in the high seas. If somebody was injured, they just like, dude, it just happened. Like, and all of a sudden there was no legislation. Like the vessels was just like literally nothing would happen there. So like there was a need of like create some sort of regulations. Therefore created like registrations and gave like vessels a flag. So they would be subject to the flag state jurisdiction in any matters. I'm doing this all the time. whenever they were like in the high seas. And this I put it here because it's interesting to say like it's actually subject to flag state jurisdictions if the high seas, but not if it is the coastal area of a state, right? So if it's the coastal area of a state, if something happens there in terms of collision, then the jurisdictions of the coastal state. So flag states literally they have jurisdiction of any, like supposedly, of anything that will happen in the high seas. So in 1927, the Permanent Court of International Justice said that vessels on the high seas are subject to no authority except that the state whose flag they fly. And then after it became like, I'm not going to go and read the article of the Nicholas because RF has talked about this article. Then Nicholas came along and decided to put state the obligations of flag states in terms of registration and the other obligations flag states had over the vessels that were registered within them. So the United States, as was pointed out by Massimiliano, has not ratified Nicholas. Nevertheless, the Nicholas is considered customary law for them. Therefore, they abide to it. And like in the United States case, that you cannot see here because I cannot share, we said like with vessels of that nationality would be international pariahs. They have not internationally recognized right to navigate freely on the high seas. Moreover, flagless vessels are like frequently not subject to laws of a flag state. As such, they represent floating sanctuaries from authority and constitute a potential threat toward the stability of navigation of the high seas. This is also something to prove, for us to connect to piracy. To pirate, what would be a pirate vessel would be a vessel that is not registered anywhere, and it's a vessel that is not subject to any state authority. So flags being registered have flag state authority. It is important for vessels navigating the high sea. It is important to say that when Nicholas provides for freedom of navigation the high seas. So I've mentioned in terms of flags, fraudulent flags. And we talked about fraudulent flags, and I think I kind of made my opinion a bit clear. And we talk a lot, there's a lot of discussion about flags of convenience. And I think Leonardo pointed out, what flags really do. So I'm going to say that I'm from a developing country, and I'm pretty much in favor of flags of convenience. And I don't want to, and I'm also a business-oriented person in terms of being a commercial lawyer. I'm very much in favor of flags of convenience, not because I'm not in favor of fraudulent registrations. I think it's not the same things of flags of convenience. Because when you talk about flags of convenience, we talk about the genuine link that RF discussed. And the genuine link, nobody could come up with a proper definition. They could, the later convention made it even more complicated, what would be a genuine link between the flag and the ship. And they said that the genuine link is how the flag exercises enforcement, right? If the flag, for instance, the flag state checks the compliance of the vessel with the technical requirements of international conventions, so on and so forth. So not necessarily that the ship company has to be a link with the country, etc., etc. Nevertheless, it's important to highlight that most cases, whenever you register a vessel in a country, they do require some sort of company registration as well. So the reason why I don't see the flags of convenience as being a problem is because it's as I said, the three main flags of convenience that we have right now are Panama, Liberia, and if I'm still correct, the Marshall Islands. And they all feature the wide list of every single port state control. And it's they consecrate most of the tonnage. And for you to register a vessel there, it's not that easy as you might think. They have Liberia is known for oil tankers registration, United States. They actually only register oil tankers that are aged only until to 25 years. So oil tankers which are older than 25 years old, they cannot register in Liberia. They have conditions because again, they don't want their vessels registered in Liberia to be detained or detained or just stopped for inspections, and they want still to be profitable and marketable in the market. So it's not like they are not like compliant with like with the international regulations that you have. So when we talk about jurisdictions in commercial law, it's quite very straightforward for us that like most of us are private international law, private law lawyers. When we talk about jurisdiction, we talk about the authority or power of the court to determine a dispute between parties, as well as the territory over which the legal authority of courts extends. And we have talked about it here, about jurisdictions all the time, the jurisdictions clause, that like in terms of contracts, Front has like talked about that in terms of ladings. We can decide which jurisdiction is going will be applied in that contract, as well which applicable law. What is the applicable law? Which might not be the same of the jurisdictions. So the applicable law will be the law stipulating a contract to determine a dispute. So in accordance with the regulation, there is express choice and maybe the implied choice that we decide according to the party's domicile, the location where the contract was made, or the location of the performance. So by this is saying that it's not necessary that the applicable law of the flag state, the law of the flag state will be applicable to the contracts, or even have jurisdictions in contracts. And when we talk about genuine link and all flags of convenience and these things, and this is being recorded. I work at one point at the Transport Workers Federation, and it's very difficult to have a contract of employment for a seafarer, which doesn't have an applicable law or a jurisdiction clause. There are private and public contracts. Filipino contracts, like employment contracts, they do have the applicable law and the jurisdiction law. It's never the law of the flag state. And it's not like I don't say that the flag state is important. Again, flag states, and this goes to my flag of convenience, is the law of the mortgage of the vessel. So again, you don't want to have the tensions in your records if you're going to have like a vessel mortgage. And the stability of the flag is important for port state control. But then, in terms of jurisdiction, and the quote is in Lotus, and I'm going to go back to the Lotus case later on, because it was funny when like the Lotus was international case about jurisdiction. And this case was exactly the case that decided first in 1927 that the ships are subject to the law of the flag. But this case is very criticized. But interesting enough, it was said by Judge Lauder, and this was the most criticized part, that he said, under international law, everything which is not prohibited is permitted. In other words, on the contention that under international law, every door is open unless it is closed by treaty or by established custom. Okay, it is debatable. I can see Professor Thomas looking at me. It is very much debatable. Oh. And this is it is questionable. It has been heavily criticized. But again, when we go back to private international law and contracts, because like Massimiliano was talking here about like legal uncertainties and everything, we try to avoid legal uncertainties. So we try to say like, let's choose jurisdiction, let's choose applicable law. Therefore, it's very easy to say that flag states do not really have jurisdictions in terms of like employment contracts. And also like one thing that I want to point out, because I kind of said that flag, that Unification is very like precise when it provides like in Article 94, when it provides duties of flag states, it reads every state shall effectively exercise its jurisdictions and control in administrative, technical, and social matters of the ship flying its flag. Assuming jurisdiction international law over each ship, its flag, its masters, officers, and crew, and its activities at some point. So it doesn't, and I'm focused on seafarers here because Mark was about social matters that are submitted to Professor Thomas. And in this part of social matters is when everyone says oh, it might apply to seafarers and oh, we're seafarers, if they fly flag of convenience, how do you have the right to force? But this is this is not necessarily the case, because like most jurisdictions say, like agree that social matters means the activities that like happen on board of the vessel, like technical activities that the seafarers, the masters, perform on board of the vessel. This was confirmed in terms of like this case from Hong Kong that I found that was very funny, because I also brought a Hong Kong case. It's not the same one. Mine is a bit different. That it's also like that it confirmed that relates to administrative, technical, social matters over the ship, including matters of marine safety and welfare of the crew. So this includes like the human rights violations, but not employment contracts. And this goes like very much into pace with what like the International Tribunal of Law of the Sea believes to see the ship as a unity. So yes, if there is a human rights violations, case of harassment on board of a ship or anything technical, yes, the flag state has jurisdictions, but not criminal acts, but not employment. Why did I do? Sorry. I think technology is not on my side. It's the thing about like someone who deals with math. It could come like you bring another computer in front of me and I get completely lost.
Social matter was the last one.
Yes. And this, in terms of employment contracts, again, like most, the other day, like Igor like asked me if I was specialized in maritime labor law. And I said no. And then I kept thinking about the reason why I said no was because for me to for myself to consider me specialized in maritime labor law, I would have to say that I would have to have knowledge of more employment law than I currently do, because I only know maritime labor law according to Filipino law, according to US law, according to English law, according to Brazilian law. The rest I don't know. But anyway, I very much do not know, and no international international conventions, international provisions. So, and also like a bit of EU, but this both EU case that like I brought to you, it also confirms that the fact that the UNIPLUS, like when they say that the fact state has jurisdictions of social matters and about the crew and the acts of the crew, is actually referring to the activities that the crew carry on board. The first one was about was a fishing vessel that was they were outside it was, I'm not going to remember the facts exactly, but they were fishing salmon when one time that was forbidden, but they were the flag was another flag, and they was in because I don't remember the country, I think it was Sweden, but the ship was flagged in Panama, and they were fishing salmon the high seas, and this was forbidden that time of the year in Sweden, and etc., etc., etc. And it was decided in favor of the ship owner because, again, it relates to the crew's activity, the law of the flag, and the flag state in that particular case was not Sweden. So the vessel was able to, the ship owner was able to sell its salmon. And in Enemico and in the Museo Stefano Strapolis was a case in Greece that the vessel never left the port of Greece, and the crew had been hired by a Bermuda company. And there, in that particular case, the European Court of Justice also reached that the flag state only governs the activities of while in the high seas, being referring to the crew activities, not to the employment of the crew. Therefore, this was a case of the insolvency, and they want the EU insolvency law to be applicable. So a seafarer living in a member state, and we're talking about a Greek crew, in EU law would be applicable. And the same goes for English law case where it has been decided that English law will apply if the seafarer is domiciled in the UK, and if it has its base of work in the UK. If it starts if he starts the work in like port in the UK, like Southampton, and he finishes like in another port in the UK, even if like during this time it was a cruise vessel, he stopped in another port, but like his job finished within, he started and finished in a port in the UK. English law will be applicable in these states. So flag state doesn't really have the jurisdiction, and like the UK will have jurisdiction. So in terms of contracts of sale of goods, like in this particular case, so it was decided that the jurisdiction of the flag states, like the flag state has jurisdiction if the damage occurs in the high seas again. But this is something that I dispute as well, is because there was no the contract. It was like, again, like the contract, it was a third party contract. So, and there was no applicable law, and therefore it was a high seas. But when we talk about contract, we have to think that like we can decide in terms of like which law would be applicable. Regardless, in terms of the dispute, regardless where the damage happened. And even like with the charter, it depends on again the recourse. So it's not like we're attributing to the flag state. And this is pretty much like when you talk about private law and like state jurisdiction. I find to be very straightforward because as lawyers, we know that we can contract. It doesn't, even if it is like employment law and we see employees as the weakest part. Again, the courts tend to see as the law being applicable, the law where they are domiciled, or the law that like, because it makes it easier for them because they are the weakest part in the contract. Frank? But then, this part was easy for me, but then I went down to a rabbit hole. And I invite you guys to go down to this rabbit hole with me. And this is still a work in progress. And why do I say that? Because jurisdiction seems very straightforward for us when we talk about private law. It's not that like straightforward when we talk about international law. So again, I'm diving rabbit hole. And then we talk about, like, let's go to the Lotus case that I mentioned in the beginning. And I'm also going to talk about another case that like I has already mentioned. In the Lotus case was a case where we had a Turkish and a French vessel that collided in the high seas. During the collision, like the Turkish, some members of the Turkish crew died. Unfortunately, they died. And both vessels were actually towed to Turkey. And once they got into Turkey, and we are talking about 1927, when they got to Turkey, Turkey arrested the masters and the first engineer of the French vessel, because accordingly, they were the ones who caused the collision. And then France obviously opposed and said, no, but Turkey doesn't have jurisdiction. The collision happened in the high seas. It was flagged vessel. So therefore, like Turkish doesn't have jurisdictions to actually arrest these two people. And he did, like again, like flag states have jurisdictions. But in this particular case, Turkey also had jurisdiction. What the court decided was very much, and there was a debate, is that both countries had jurisdiction in this case. They had concurrent jurisdiction. And then, like, there was a lot of, like, during the time that it was decided that flag state indeed has jurisdictions, but in this particular case of a collision, both of them would have. It was very much discussed that, like, oh, if you see, like, some Danish authorities said, like, but if you see the flag state as the vessel as an extension of the flag state, we also need to consider that the water around the vessel would be like continental shelf of the vessel, which is not necessarily true, right? But like, which is not true at all, actually. But it was like saying that was had concurrent jurisdictions, and that creates like somehow like some sort of like conundrum international law, like that it creates the fear that like everything that happened in international waters, not necessarily the flag state to have jurisdictions in the activities. So in this case, when it was decided, and I have to say, I'm going to be discussing more the operative case rather than the decision itself, because I'm a woman, I like contradictions more than decisions, because like, again, like, and I'm a lawyer as well, so I like to delve into contradictions to make an argument. So in the ruling, it was said that now the first and foremost restriction imposed by international law upon a state is that failing the existence of a permissive rule to the contrary, it may not exercise its power in any form in the territory of another state. In this sense, jurisdiction is certainly territorial, not be exercised by a state outside its territory, except by virtue of a permissive rule derived from international custom or from convention. Meaning that in this particular case, Turkey could not have arrested the French officials because they were, when the accident happened, it was in the high sea, and again, they were like in a French vessel. But there is an exception to the exception. It does not, however, follow that international law prohibits a state from exercising jurisdiction in its own territory in respect of any case which relates to acts which have taken place abroad and in which it cannot rely on some permissive rule of international law. Far from laying down a general prohibition to the effect of that states may not extend the application of their laws in their jurisdictions of the courts to the person's property in acts outside the territory. It leaves them in this respect a wide measure of discretion, which is only limited in certain cases by prohibitive rules. As regards other cases, every state remains free to adopt the principle which it regards the best and most suitable. Therefore, Turkey could have arrested officials. Like no doubt here, right? So created like a certain conundrum, created like expectations, and it was very much decided. But the problem with international law is that jurisdiction is not as straightforward as is in private law. We have three types of jurisdictions. Bear with me here. We have, I didn't know that, you might have known that, but I'm not an public international law lawyer, I didn't know that. There are three types of jurisdictions: prescriptive jurisdiction, adjudicative jurisdiction, and enforcement jurisdiction. So the prescriptive jurisdiction is to prescribe, to make its law applicable to the activities, relations, or status of persons, or the interests of persons in things, whether by legislation, by executive act, or by administrative rule or recognition, or by determination by a court. Whereas adjudicative jurisdictions is to adjudicate, i.e., to subject persons or things to the process of its courts or administrative tribunals, whether in civil or in criminal proceedings, whether or not the state is a part of the proceedings. Enforcement jurisdictions to enforce or compel compliance or to punish non-compliance with its law or regulations, whether to the courts or by use of executive, administrative, policy, or their non-judicial action. Therefore, what we have in international law is that you might not have enforcement jurisdiction, but you might have prescriptive jurisdiction, and you might have adjudicative jurisdiction. So one doesn't necessarily, like not having one of them excludes you having the other. So this creates, like again, like the conundrum, and also means that flag states will not always be the case that flag states will have jurisdiction, actual factual jurisdictions over like the acts of this vessel. Whenever the vessel is the high seas. The first two types of jurisdictions, they always have the necessity of a nexus between the country that has jurisdictions and the accident, the incident itself. The third one as well, but if they have the nexus and they can prove the nexus and like why it's important for them to have the jurisdictions, they still can have the jurisdictions. So in the most recent commentary in 2017 of the Nicholas Article 921, I said that the provision creates only a prohibition of exercising enforcement jurisdictions over foreign vessels on the high seas. Multiple states might still attach legal consequence to acts committed on vessel on the high seas as a matter of prescriptive jurisdiction. Therefore, not exactly, so therefore it's just literally saying that flag states will not necessarily have jurisdictions over acts that are committed like in the high seas, other states might still attach legal consequence to these acts. And again, everything that is not prohibited in international law is permitted. So these just go to the first slide that I said. So in the MG saga that RF commented, because it talks about the genuine link, he brought because of the genuine link. I'm not bringing because of the genuine link. So two different cases. It was a case of illegal bunkering. And that's why they wanted to, the legal activity was bunkering, which is the most case was illegal bunkering. And they wanted like the crew to be, because of the illegal arrest, etc. They demanded like the claim for compensation for the crew, for everything in terms of the detention, the illegal detention. And more recently in Italy, there was the MV North Star case that like it was in 2016, that it also involved illegal bunkering, meaning the North Star was actually providing oil to yachts in the high seas, to Italian yachts, like for a more reasonable price. Italian and Spanish yachts, but like this case was slightly more complicated because like Italy issued an arrest warrant for the vessel to be conducted by the Spanish courts. So the Spanish courts were the one that detained the vessel, according to the Italian arrest vessel, saying that like the vessel was committed like fraud according to Italian legislation, etc., etc. And then like Panama said, but we were actually, these acts were being done with the high seas, the bunkering. So they're subject to Panamanian law, not Italian. Italian lost this case, by the way. So this saga, okay, I'm going to run. So it was again the thing that I brought because it's the case said that the ship as a unit regards the obligation of the flag states and like the acts that conveyed like that happened in the flag state. So I'm going to jump the MV saga for a bit, like what's said in terms like it actually through the MV saga we had the Law Commission draft a diplomatic protection, in particular Article 18 of the protection of ship crews, which reads as follows: the right of the state of nationality of the members of the crew of a ship to exercise diplomatic protection is not affected by the right of the state of nationality of a ship to seek redress on behalf of such crew members, irrespective of the nationality, when they have been injured in connection with an injury the vessel resulting from international wrongful act. In this particular, I brought these up because it literally says that the flag states, and this is when we get a bit confused, it doesn't necessarily, it doesn't always have, in most cases, does not have jurisdictions over the seafarer's employment contract, but they do offer the seafarer some type of protections when they seek redress by something that it was an act that was committed by a second state. Like it was the case of Turkey, that arrested the French officers. Also in terms to make things easier, because when we're talking about vessels, we have sometimes 3 to more nationalities on board. So it would be easier for a flag state to have this responsibility, which is not to say that it has jurisdictions over the employment of the seafarers or the contract, etc., in terms of conditions. In the North Star case, it was very complicated. It's a very complicated case because Italy also claimed correctly, in my opinion, that Spain should have been called because Spain was actually the one that detained the vessel, later released the vessel, but never informed the Panamanian authorities that the vessel had been released and the vessel that had been sold to scrap. And Panama, instead of involving Spain, the procedures only involved Italy because Italy was the one that issued the arrest warrant. And in this particular case, it was when the Lotus came again, in the Lotus case came again to light. I really thought that was on time. So it came into light in terms of we can have prescriptive and adjudicative jurisdiction, but not enforcement jurisdictions, and it's okay to have concurrent jurisdictions. So in this case, we decided that any act which subjects activities on a foreign ship of the high sea to the jurisdiction of states or the flag state constitutes a breach of freedom of navigation, saving exceptional case, etc. And when analyzing this breach, because they said, because since the vessel, Italy was actually issuing the arrest of a warrant for the vessel for a bunkering activity that it was conducting in the high seas, and therefore would limit the freedom of navigation, and the high seas was subject to Panamanian law. When analyzing this breach, the tribunal said that it prohibits not only the exercise of enforcement jurisdiction on the high seas by states other than flag state, but also the extension of the prescriptive jurisdiction to lawful activities conducted by foreign ships on the high seas. And then I bring in, there was extended view, because I love the extended views as well. Again, I said that I was going to talk about the opposite So, and you say that like the exclusive flag state jurisdiction prohibits the extension of the prescriptive jurisdiction to lawful activities. So, according to the standards, it just seems to suggest that a non-flag state is not excluded from standing in conformity with international law. It's prescriptive jurisdiction to unlawful activities of foreign vessels persons in the high seas. So essentially saying that Italy did have a case, right? So a state may exercise its prescriptive criminal jurisdiction with respect to conduct on the high seas, where such conduct is integral to an alleged crime committed to the state's territory, not when it's justified or allowed by international law to do so, but when it's prohibited by international law to do so. But the fact that North Star never committed like a legal act in the Italy coastal waters was only the high seas. And also the fact that Spain was not involved here, and like Italy actually conducting the ban. And then again, it came with Italy again on Iorna, but like Italy won this game. So in the Erika Lift Lexi case was a different case, again involved like and this one is involving illegal bunkering activities, was like Italian vessel like saw an Indian fishing boat like international waters, tried to contact, like send signals to the fish, like to the fishery ship, and they did not get any response and assumed that it was a pirate ship. Therefore, they had 2 Marines on board and they opened fire. They didn't kill anyone, but they opened fire. And the vessel ended up like in India. When it got to India like arrested the vessel and arrested the 2 mariners who opened fire against like Indian ship, like fishermen. So in this case, the reason why India lost was not because it didn't have prescriptive jurisdiction, because it wasn't the high sea, but it had, like, the court decided that it had a prescriptive jurisdiction and prescriptive jurisdiction. What happened is that, like, according to international law, the mariners had an exclusion for liability in this particular case. Therefore, they have to liberate the mariners, but not because India did not have jurisdiction over the case. So it was only because another international law, create the fact that they did not have, they were immune of persecution, these 2 Italian mariners. So my conclusion, and I could talk about another vessel in terms, but my conclusion is, and I'm sorry that I rushed now, is that it's essentially a ship as an extension of the flag state territories. This is a legal fiction that we create in terms of protection in the high seas. Is it limitless law though? Apparently it's quite not. So I'm attributing so many in terms of flag state jurisdictions and saying in terms of flag state responsibilities to create the fact that we can have other other states can have jurisdiction. And why is this important? A few years back, it's going to take 1 minute. So a few years back in a cruise ship, an English miner was harassed again, and I'm sorry, must be by Italian. Was harassed by Italian, and it was the vessels in the high seas at the time of their sexual harassment case. And she was a minor. It was not a very different age gap. She was 16 and the Italian guy was 18, 19. But again, she was a minor. There was a sexual harassment issue. Whenever the vessel, the high seas, the vessel was flagged under was flagging the Panamanian flag. So as soon as the cruise vessel stopped in Spain, the Italian was arrested. And obviously, the Spanish court said, we don't have jurisdiction in this case. First, they were dealing with 2 persons who were not their nationals, 1 Italian and 1 English, and now after Brexit, not even a new member, the second one. And it was a Panamanian flagged vessel in the high seas. But this doesn't mean if the girl had wanted to sue the Italian boy, because he was 19, to me he was a boy still. Boy in England should not have a case, because again, international law in the English courts could have prescriptive and adjudicative jurisdiction over it to the criminal act, because it was committed against a national of that particular country. Obviously, then becomes the conclusion: is it worth it it's obviously not worth it, because then we have to issue like an arrest warrant to Italy to have this person like again like sent back, etc. We have to go to treaties. It's not like, again, as lawyers we do advise our clients, it's not really financially worth it. But that doesn't necessarily mean that was because like Panama had jurisdiction of this case, was assigned to her. Again, there is always this linear bar that like there is more than one state that can have jurisdiction over a criminal act, not necessarily enforcement. With this, I conclude my presentation. I'm sorry for taking a bit longer. I do apologize. Thank you so much.